Imagine waking up one morning, checking your phone, and finding out that working legally in America just got thousands of dollars more expensive overnight. No warning, no grace period, just a new rule, and a brand new price tag on your dream. That is exactly what is happening right now. And if you or someone you love is working in the United States on a visa, applying for a green card, or waiting for work authorization, this video could save you thousands of dollars and years of confusion. Stay with me, because what I am about to share changes everything. This is a breaking update that every immigrant in America needs to hear today. The United States Citizenship and Immigration Services, known as USCIS, has finalized a major new rule that directly impacts the cost of working legally in the United States. We are talking about a combined fee burden that now reaches as high as $2,965 just to apply for or maintain your work authorization in this country. This is not a rumor. This is not speculation. This is the new reality of the U.S. immigration system in 2026, and it is already affecting hundreds of thousands of immigrants, visa holders, international students, H-1B workers, and green card applicants right now. This rule comes on top of an already strained immigration system, one where backlogs are running into decades, processing times are unpredictable, and immigrants are constantly being asked to do more, pay more, and wait longer. And now, with this updated fee structure fully in effect, the financial barrier to legally working in America has reached a historic high. So what exactly changed? Who is being hit hardest? What mistakes are people already making? And most importantly, what should you do right now to protect yourself? We are going to answer every single one of those questions today, step by step, in plain, simple English. To understand why this is such a massive deal, you need to understand how USCIS fees work and why they matter so much. USCIS is the government agency responsible for processing immigration applications in the United States. Unlike many government agencies, USCIS is almost entirely funded by the fees it collects from applicants, not by taxpayer money. This means that every time you file a form, every time you apply for a visa extension, every time you renew your work permit, you are personally funding the operation of the agency that decides your fate. For years, immigration advocates and legal experts warned that the USCIS fee system was broken. The agency faced enormous backlogs, outdated technology, and a workforce stretched too thin. Processing times ballooned. People waited years just to get a simple renewal approved. Meanwhile, the fees being charged had not kept up with the actual cost of running the agency. So in 2024, USCIS announced one of the largest fee increases in its history. That rule took effect and began reshaping the financial landscape of U.S. immigration overnight. But that was just the beginning. In 2025 and into 2026, additional regulatory changes layered on top of that base fee increase. New surcharges were introduced. The asylum program fee, a controversial charge added to employment-based petitions, remained in place and was expanded. And the cost of filing for employment authorization documents, also called EADs, was restructured in a way that left many applicants paying far more than they ever expected. By the time all of these changes were calculated together, the base filing fees, the biometric service fees, the asylum program surcharge, and the new processing enhancements, the total financial burden on many applicants crossed the $2,965 threshold. And that number is now front and center in every immigration lawyer's office across the country. Let us now break down exactly what makes up this new fee structure and how it reaches that $2,965 figure. The first piece of this puzzle is the revised base filing fee for employment-based petitions. USCIS significantly increased the fee for Form I-129, which is the petition employers file to sponsor workers for H-1B visas, O-1 visas, TN status, and other non-immigrant work categories. The new I-129 base fee for H-1B petitions now stands at $730. Nearly double what it was just a few years ago. The second piece is the asylum program fee. This is perhaps the most controversial addition to the fee structure. USCIS now charges an additional $600 on top of Form I-129 filings for most employers petitioning for non-immigrant workers. The stated purpose of this fee is to help fund the processing of asylum applications, a completely separate immigration track. Many employers and legal advocates have called this fee unfair, arguing that H-1B workers and their employers should not be subsidizing the asylum system. But the fee is real, it is law, and it is being collected right now. The third piece is the updated fee for Form I-765, the application for employment authorization. This form is what gives immigrants the legal right to work in the United States. For many categories of immigrants, including those on OPT, those with pending adjustment of status applications, DACA recipients, and asylum seekers with work authorization, this form is essential. The new filing fee for Form I-765 now sits at $520 for paper filings, with online filings slightly discounted at $470. This is up significantly from the previous fee of $410. The fourth piece is the biometric services fee, which has been restructured. While USCIS eliminated the separate biometric services fee for many applicants as part of its 2024 overhaul, the cost was simply folded into the base application fee, meaning applicants are still paying for it, just in a less transparent way. And the fifth and final piece, the one that pushes the total toward that critical threshold, is the premium processing fee for employers and applicants who cannot afford to wait. The fee for premium processing, which guarantees a decision within 15 business days, now sits at $2,805 for I-129 petitions. When you add the base fee, the asylum surcharge, and premium processing together, the total climbs to $3,535 for some categories. But even for those not using premium processing, the combination of fees across a full employment authorization cycle has reached that $2,965 mark for many applicants. This is the new cost of working in America, and it is only going to grow. Now, who exactly is being hit by these new fees? The answer is almost everyone in the employment-based immigration pipeline. H-1B visa workers and their employers are among the hardest hit. If you work in technology, engineering, healthcare, finance, or any professional field that commonly sponsors H-1B visas, your employer is now paying significantly more to keep you in legal status. Some small and mid-size employers are already saying they cannot afford to continue sponsoring international workers at these new rates. International students on F-1 visas who are applying for optional practical training, OPT, or STEM OPT extensions are directly impacted by the increased I-765 fee. Many students are already operating on tight budgets, and an extra $100 or more may sound small, but when combined with lawyer fees, transcript costs, and application expenses, it adds up fast. Immigrants with pending adjustment of status applications, meaning people who are in the process of getting their green cards, also face higher costs. Filing Form I-485 for adjustment of status now carries a base fee of $1,440 for most applicants, with additional fees for biometrics folded in. DACA recipients face their own unique pressures. The fee to renew DACA, which includes both the Form I-821D and the I-765, sits at $550 per renewal cycle. For a population that is largely young, working class, and without access to federal financial aid, every dollar counts. Asylum seekers with pending cases who need work authorization are also caught in this system. Even while waiting for their asylum case to be resolved, a process that can take years, they must pay the I-765 fee to maintain legal work authorization. And employers, from small businesses to large corporations, are feeling the full force of these changes. Every petition, every renewal, every extension now costs significantly more, and many companies are reevaluating their international hiring strategies as a result. Let me paint you a real picture of what this looks like in everyday life. Take Priya, a software engineer from India working on an H-1B visa in Texas. Her employer needs to file her H-1B extension this year. The company's HR department calculates the total cost: base I-129 fee, asylum program surcharge, attorney fees, and other documentation costs. The bill comes to just over $3,000. The company's CEO, who runs a mid-sized startup, calls a meeting and says they need to reconsider whether they can continue sponsoring international employees at this rate. Priya is now facing an uncertain future, not because of anything she did wrong, but because the cost of keeping her just became too high for her employer. Now consider Marcus, a Nigerian-born nurse living in Florida with a pending green card application. He filed his I-765 to get his employment authorization document so he can continue working while his case is being processed. He pays the $520 filing fee. 3 months go by, 6 months go by. His EAD is expiring, and USCIS has not issued a renewal yet. He can no longer legally work. He loses his job. His savings begin to disappear. And when he finally calls USCIS, he is told there is no expedite available unless he pays the premium processing fee, $2,800 more, or he waits. And then there is Sophia, a Colombian student finishing her master's degree in California. She applies for her OPT work authorization 6 months before graduation, exactly as the rules require. She pays the I-765 fee. But she made one mistake. She did not file through the USCIS online system, and she paid the slightly higher paper filing fee. A small difference, but for someone managing student loans and living expenses, every dollar matters. These are not rare cases. These are the everyday experiences of hundreds of thousands of immigrants navigating the American immigration system in 2026. Now let us talk about the mistakes people are making right now, because the wrong move in this environment can cost you everything. The first mistake is waiting too long to file. With processing times still unpredictable and USCIS backlogs not yet cleared, filing late is one of the most dangerous things you can do. If your EAD expires and your renewal has not been processed, you could lose your ability to work legally, even if you did nothing wrong. File as early as the rules allow. The second mistake is not using the USCIS online system. USCIS now charges a lower fee for applications filed online compared to paper. Many applicants, either out of habit or mistrust of online systems, are still mailing paper applications and paying $50 more than necessary. Over multiple applications, this adds up to real money. The third mistake is not understanding which fees are refundable. USCIS filing fees are generally non-refundable. This means that if your application is rejected, not denied, but rejected for a technical reason like a missing signature or wrong fee amount, you lose that money and have to refile and repay. Double-check every single form before you submit. The fourth mistake is assuming your employer is paying all the fees. Some employers cover all immigration costs, others split costs with employees. Some expect workers to cover certain personal application fees themselves. If you do not have a clear written agreement with your employer about who is responsible for what, you could be blindsided by a bill at the worst possible moment. The fifth mistake is ignoring the fee waiver option. Certain applicants, particularly asylum seekers, people experiencing financial hardship, and some DACA recipients, may qualify for a fee waiver on certain forms. Too many eligible applicants never apply for the waiver simply because they do not know it exists. If money is genuinely tight, ask an immigration attorney or a qualified nonprofit immigration organization whether you qualify. So what should you actually do right now to protect yourself and your immigration status? First, audit your immigration timeline immediately. Look at every form, every visa, every status document you hold. Find out when things expire. Build a calendar of upcoming filing deadlines. Know exactly when you need to file each application, and plan to file at least 6 months in advance wherever possible. Second, budget for these new fees now. Do not wait until you receive a notice to start thinking about money. Create a dedicated savings fund for your immigration costs. If your employer is supposed to cover fees, get that agreement in writing today. Immigration surprises are rarely pleasant, and financial surprises on top of immigration stress are even worse. Third, Create a USCIS online account if you do not already have one. Filing online is cheaper, faster, and gives you real-time case tracking. There is no reason to be paying extra for paper filing in 2026. Fourth, consult a qualified immigration attorney before making any major decisions. This is especially important if your situation involves premium processing, employer transitions, pending green card applications, or any kind of gap in your work authorization. The cost of one good legal consultation is almost always far less than the cost of a filing mistake. Fifth, stay informed. Immigration rules are changing faster than ever. A policy that is true today may be different in 60 days. Subscribe to reliable immigration news channels, follow USCIS official announcements, and be skeptical of advice from unqualified sources on social media. Looking ahead, the signals from Washington are not pointing toward relief on fees anytime soon. USCIS has indicated it will continue reviewing its fee schedule on a regular basis, and further increases are likely as the agency works to reduce its multi-year backlog. The Biden-era fee rule that created much of this new structure has not been reversed, and the current administration has signaled support for continued agency self-funding through applicant fees. There is also significant congressional pressure around the H-1B program, with both supporters and critics of the visa category pushing for reforms that could alter the fee structure further. Some proposals would increase fees even more dramatically for large employers who rely heavily on H-1B workers. Others are pushing to reform or eliminate the asylum program fee, which is facing legal challenges in several federal courts. The EAD processing time crisis is also not going away. USCIS has made some improvements, but the backlog of I-765 applications remains a serious problem, and many analysts expect that premium processing for EADs, once a rare option, will become increasingly common simply because people cannot afford to wait. For immigrants in the employment-based green card queue, particularly those from India and China facing century-long backlogs due to the per-country cap, the combination of high fees and endless waiting is becoming genuinely unsustainable. Advocacy groups are pushing for legislative reform, but in today's political environment, passing comprehensive immigration reform remains an enormous challenge. What is clear is this: the cost of legal immigration to the United States is rising. The system is under enormous strain, and the people caught in the middle are the immigrants themselves. Hardworking, law-abiding people who are simply trying to build a life in this country the right way. Here is the truth that nobody in Washington wants to say out loud. Legal immigration was never easy, and right now, in 2026, it is harder and more expensive than it has ever been. The $2,965 price tag on working in America is not just a number. It is a symbol of a system that has become increasingly difficult for ordinary immigrants to navigate alone. But you do not have to navigate it alone. That is exactly why this channel exists. Every week, we break down the most important U.S. immigration updates in plain, simple English, so that whether you are an H-1B worker, an international student, an asylum seeker, or someone on the long road to a green card, you always know what is happening, what it means for you, and what to do next. If this video helped you understand something that felt confusing before, if it saved you time, saved you money, or simply made you feel less alone in this process, please do one thing right now. Hit the subscribe button, turn on the notification bell, because the next immigration update could be the one that changes your life, and you do not want to miss it. Share this video with someone you know who is going through the immigration process. They need this information. You could be the reason they avoid a costly mistake. The path to working legally in America has always required sacrifice. But sacrifice is easier when you know exactly what you are walking into. Stay informed, stay prepared, and we will be right here every step of the way.